Hey everybody, it's Tyler Flood, Houston, Texas DWI defense attorney, and we are back with another session of Ask the DWI Expert today, April 24th, 2015. And we're doing this from the office today. You can tell by the shades and the certificate on the wall, not an exotic location like we normally do. But anyway, I think we've got more participants today and more questions. We're starting to gather a following, which is good. Tell your friends. The purpose of this chat session is to make myself available to answer any DWI questions that you might have. Blood draw questions, breath test questions, trial strategy questions. If you have a case and you're struggling with an issue, I've been there. I had to figure things out on my own the hard way. So I wanted to make myself available to answer questions for you guys and just to kind of have a forum to go over issues, provide advice, and solve some problems and help you be more effective in that courtroom. So this week was a good week. I'm glad it's Friday, but we had a .14 blood draw case where my client admitted that she said, I'm drunk, 2 times on the video to the officer. And she said, I know I've had too much to drink. I shouldn't be driving. And we still got a not guilty verdict. Would y'all mind closing those doors? So I think that we have some questions coming in. We just picked a jury today as well and broke for the day. And we are going to resume trial on Monday. That's good. That's good. Thanks. Okay. Let's go to the first question or comment. What is a Brady violation? Did you, hang on one second. Shelly, it was my research assistant on this and asked her to pull up some Brady material about what Brady actually means, and just waiting for her to give that to me because I didn't see it. I know what Brady evidence is and Brady material, but I wanted to be able to read off of something, the actual meaning of this is a Supreme Court case, Brady versus Maryland. So when you're a young prosecutor, they say that you have Brady training, and that means that they teach you what Brady is, Brady evidence is, and when you're supposed to disclose it, which is all the time. But there's a difference between Brady, and trial Brady. Sometimes Brady, and I learned this from the great Troy McKinney, there is some Brady that needs to be disclosed before trial, and it's just Brady all the time. And there's some Brady that you only get to find out about if you're actually going to trial. So there's one case that we had, and we had to actually announce ready for trial that day before the Brady was disclosed to us. And it was about a problem with a witness in the case. And I was really confused about why that Brady evidence wasn't given to us before trial. And I learned the difference between trial Brady and regular Brady. So a lot of lawyers out there are not finding out about Brady evidence because they're not announcing ready for trial. So basically, Brady versus Maryland was the landmark case from 1963, United States Supreme Court. And there was the problem was the prosecution had withheld evidence from the defendant in the case, was convicted, and they challenged his conviction, arguing that it had been a violation of due process, the due process clause of the 14th Amendment of the Constitution. So the Supreme Court held that withholding exculpatory evidence violates the due process clause. And so it's where the evidence is material either to guilt or punishment. And the court determined that under Maryland state law, the evidence that was withheld could I'm sorry, this goes to Brady disclosure. So anything that is exculpatory must be disclosed by the prosecutor. Exculpatory, for lack of official definition, means evidence that would likely show that the accused is not guilty of the offense charged, or is mitigating, or helps with the defense towards the charges. And here's two examples of what has happened to us recently. So a Brady violation is when the prosecutor knows about exculpatory evidence and they don't disclose it to you. The prosecutors that we try most of our cases against are brand new. They're just fresh out of law school. These are the prosecutors that need the most help in understanding what Brady means and what exculpatory evidence means, and when the duty to disclose Brady evidence kicks in. It seems right now we're definitely due for some more serious Brady training at the Harris County DA's office. There was a case that we tried recently, and on the condition of the blood, on the blood form, it listed the condition of the blood as simply green in one spot. Well, so we consulted our expert, Dr. Jimmy Valentine out of Mississippi, researched every treatise that we could find, and we know a thing or two about blood condition as well. And we all talked about it, brainstormed, asked everybody that we could talk to about what does green mean? Why would it be green? Normally, in post-mortem blood, it's common to find green blood. And but nobody said anything to us about why the blood was green. So this is the blood. This is evidence that's being used in an effort to convict a person at trial. So the prosecutor never said a word to us. The DPS analyst took the stand, never said a word to us about the green blood. As a matter of fact, when the prosecutor asked the DPS analyst if there were any issues surrounding this test result, the answer was no. There was not any problems with this blood test. So I took a shot in the dark on my closing, and I said, you know what? This document right here says that the blood was green. And what do we know about things that turn green? That means that they're decomposed. Meat, milk, cheese, things like that, they turn green when they decompose. So our argument to the jury was that this evidence was decomposed, and they tested it anyway, and they had no problem with that. Well, after the trial, which ended up in a conviction, guess what? We found out from the analyst that she said, oh yeah, I knew the blood was decomposed. And we found out that the blood was hemolyzed, which is the bursting or the breaking of the red blood cells, which can cause a higher BAC level because it releases more ethanol into the blood sample. The prosecutor knew about the decomposed blood as well, but he said, well, I'm not going to ask about it. We'll just see if the defense attorney brings it up. This is a violation of Brady versus Maryland. Clearly, we have a motion for new trial pending. Even today, the prosecutor, instead of accepting the suggestion or education about what Brady is and how is a great guy, good prosecutor. I think he's very professional, and I think he has good ethics, but he hasn't been educated on what Brady means and when to disclose that. So, if you see this, you know who you are. It's nothing personal. We are in an adversarial system, okay? While we all want to be friends and play nice, we have a job to do and a duty to do to our clients. So it's an adversarial process. If you fail to disclose Brady information, we're going to take the necessary legal remedies to fix that problem. And when you know that blood was decomposed, that's Brady material. I think he asked me, well, how is it that if there's a problem with the blood, how is that Brady? And then I realized a complete fundamental breakdown of the Harris County DA's office in educating their young prosecutors what Brady material is, what even probably the word exculpatory means. The key piece of evidence used in that case against our client was the blood evidence. The blood evidence was green. The blood evidence was decomposed, and nobody mentioned it before trial at all. And still, even after I explained it that way, the prosecutor didn't get it. And he said, I'm just not seeing how that's exculpatory. So when we told him that we're filing a motion for new trial, he took it personally and got offended. And he said, oh, I'm going to go around and tell everybody that you guys can't be trusted. And if you and my response was to my associate when I heard that, I said, you know what? That's fine, because anytime I see a Brady violation and I find out that a prosecutor is withholding exculpatory evidence or exculpatory material, I'm going to take legal action to rectify that problem. And we can go tell all of our 750 members about how you withheld exculpatory evidence that should have been disclosed before trial. So I think that you need to have some caution and think twice about what you start going to tell other people about how you withheld Brady information. And I feel very strongly about this. And yes, every time this happens, I will take the same action. So another case we had where Brady was withheld was in a case where, crazy set of facts, our client hit another person on the road and then got out of his car and ran and hid in the bushes. The number one witness for the state was a young man who said the officers, in order to get the warrant for the blood, the officers wrote down that this person saw my client driving the car, get out of the car, and run and hide in the bushes. Well, they subpoenaed him for trial. Turns out, first of all, he wasn't available for trial, even though we asked if he was subpoenaed. Second of all, when asked where is he, the prosecutor said, we changed our mind about using him at trial. And we asked why. So I called him, and it turns out that his story was, Mr. Flood, I've been called so many times by those prosecutors, and I told them, I never saw your client driving the car. I never saw him run from the car and run into the bushes. If I saw him in a courtroom, I would never be able to identify him. I don't even know if he has brown hair, blonde hair, or anything about what he looks like. I probably don't need to go into as great depth talking about how this is exculpatory, because the reason that the blood warrant issued was based on that witness's statement to the officers, which turned out to be a complete lie. And the prosecutors did not call him to trial for that reason, because he said he never saw my client driving, and he's the only one that could identify my client driving. Were we ever told this before trial? No. And the same reaction when we said this was Brady and exculpatory and should have been disclosed. Instead of taking it to heart and maybe considering for a second that after practicing 14 years and becoming board certified in criminal law, I might know something about Brady, they decided to become defensive and told my associate, we're going to go tell every other prosecutor bad things about you guys because you, I don't even know the reason, because we're requiring them to disclose Brady evidence as required by the Supreme Court decision. So please do go out and tell all the other prosecutors that we're going to hold them to the law, and you should not violate Brady versus Maryland. And if it happens again, we're going to take steps to correct that problem. And maybe this will help fix the problem, and people will start disclosing Brady evidence in the appropriate situations. So spread the word that, yes, it's important, and you should disclose Brady. So let's answer some questions. Sorry about my little rant, but I took it personally. We have a job to do. Sometimes it's not fun on both sides, but the wrong reaction is to go around trying to badmouth a defense attorney for your failure to disclose Brady evidence. Okay, I heard that sometimes officers use the old DIC-24 form. Why would they use that? Just being sloppy? And number two, what is the proper argument, motion to make at an ALR hearing to get a negative finding by an ALJ, administrative law judge? Exact phrasing, please. I have no idea. Let's go on to the next question. No, just kidding. Okay, well, there's an old DIC-20 form. These are the documents that DPS uses that they have to read you in order to obtain a legal breath or blood specimen, or to suspend your driver's license if you refuse to give a specimen, or if you give a specimen and you're over the legal limit of 0.08. The old forms did not advise the subject that if they refuse to give a specimen, a warrant can be obtained to draw their blood. That changed, what was it? September 2011. And the new forms have that language, and it's required. And DPS will not, or I'm sorry, the State Office of Administrative Hearings, the administrative law judge will not suspend a person's driver's license if that proper form is not used, because it is not a complete and accurate set of legal statutory warnings about the consequences of refusing to give a breath test. The subject must be advised that if they refuse a breath test, a warrant can be obtained to draw their blood. Otherwise, it's insufficient legal warnings. So the way that I would handle this at an ALR hearing is we still see this maybe about, 2 out of every, 30 or 40 cases. They'll use an old form. Some of the smaller agencies, precinct constables do this sometimes too, but you just object. You can object to the document coming into evidence because it's an improper warning. You can object because it's irrelevant, because it doesn't obtain the proper statutory language, or you can just argue it on closing and say, Judge, the department can't meet their burden for a suspension or a proper denial because the subject wasn't properly informed of the consequences of refusing because of the insufficient language surrounding the warrant. So if you see that DIC-24 and it doesn't say we can get a warrant if you refuse a breath test, then raise that to the ALJ and say it's outdated. It's got to obtain that language. Otherwise, it's not a valid statutory warning. Yeah, that's way too much for me to read. So let's move on to the and too small font for me. My eyes aren't as good as they used to be. So let's go on to the next question. The prosecutors knew about, so going back to the Brady question, the prosecutors knew about the evidence. Why didn't they tell me? What do I do? Oh yeah, so this is good because this is the procedural question. I looked this up and I researched this, and hopefully we protected the record correctly on appeal. What you do when you think there's a Brady violation during trial is you must, first of all, you must request a postponement. That's what the language was. I think it's the equivalent of a continuance, and judges can grant in-trial continuances, but you need to be on the record, of course, because if it's not on the record, it didn't happen. You need to request a postponement of the proceedings because you learned about new Brady exculpatory information, and this one where the witness changed his story, or he never really said that in the beginning. We don't really know. But the story was that he didn't see the person driving, and the state said that's why we're not calling him as a witness. Well, we didn't find that out until that day in trial, so I followed proper procedure and requested a postponement. He had been subpoenaed, and I said, Judge, I have a right to, Sixth Amendment right to confront this witness. It's what the basis is for the probable cause affidavit and why the warrant issued. And the case was so old that, I understand the judge didn't want to postpone it any further, but I think that she had a legal duty to do so. Otherwise, I think we protected the record on appeal sufficiently. And then I also requested, the other remedy is to exclude all of the evidence from that stems from the Brady violation. And that didn't happen either. So we have this case on appeal. I don't want to name the judge. It's a judge I love dearly, and I think she's a great judge, and we want her on the bench. But there's interest in moving the cases along, and sometimes, we don't. Brady violations, most lawyers don't raise them, and a lot of people are very unfamiliar about the legal remedies and procedures that should be followed. But the only other thing was I didn't even see that we were supposed to request a writ of attachment either, but that couldn't have happened because the witness was in Louisiana, and I brought this up to the judge. So I think the proper procedure is you request a postponement, and then you request exclusion of the evidence. And I think the record is sufficiently protected if you do that. Okay, is there any way to get prosecutors to hold them accountable for violating Brady? There is, and just the procedures I went through. Also, I think it's important to just try to impress upon the superiors, the elected official, that there's a real need for Brady training in these younger prosecutors. When I was young, I didn't know anything about what I was doing. I'll be the first to tell you, and that's why it's called a practice, because I'm still learning today, and I learn something new every day in this practice. When you're young, as an attorney, you come out full of salt, full of sand, or however the saying goes, and you want to have a fight. And you don't want anybody accusing you of doing something wrong, and it's not comfortable. But we were right, and they were wrong. And the proper response should have been, maybe I can learn something from this senior attorney. That's kind of my attitude. The way I would have been is that I didn't know what I was doing back then. And if someone told me, hey, that's Brady and you messed up, I would have gone and researched it and asked somebody about it and educated myself. And I probably would have been the first to acknowledge if I had made a mistake. It's disappointing to see two young prosecutors with potential turn the other direction and would rather just go badmouth one of their colleagues in the same profession when it's something that they clearly violated. But I don't think that you should, in this circumstance, it's not grievable. I'm not going to do anything like that. We may write a letter raising it to some of the superiors just as a call for help, because real people's lives are being affected by this, and there's some renegade attitudes and a lack of concern over having to turn over Brady evidence. So, all right, let's go on to the next question. I think I beat the Brady thing to death. Is it appropriate to perform HGN on someone who has a lazy eye? What about blindness in one eye? That's an interesting question. I think that if a person had an eye problem and the officer is reporting 6 clues out of 6 on the HGN, and you can prove that the person has an issue with an eye, that definitely calls into question the reliability and the weight given to the HGN. What about blindness in one eye? They should not be getting 6 clues on the HGN, but maybe 3, but maybe probably the HGN shouldn't be done at all in that situation. And hopefully, actually, I think there was a case one time where somebody had a glass eye, or there was a real problem, and the officer still did the HGN, and we were just perplexed that they would even get up there and report those results. So is that a serious question? Anyway, how about this one? Yeah, we've already answered that too. That's all the questions I have. And we're, I guess,
one more.
Since we have 1 more minute, we got time for maybe 1 more, but I didn't get very many questions today. Please tell your friends, and I know it's kind of cumbersome to go through the Google Plus process, but I'm here giving out free advice about any of your DWI questions, and please use me as a resource, or else suffer the consequences. No, I'm just kidding. We want to stick around. We want to help people. So please encourage more people to join our chat every Friday, and then we're going to upload them to YouTube as well. Okay. How do you deal with an admission by the client of feeling drunk or buzzed on video? That's a good question. And so there's different ways to deal with that in different circumstances. In one way, something that officers do right now is they say on a scale of 0 to 10, where would you, 10 being intoxicated, where would you rate yourself? And I have clients saying 2 and 3 a lot. So the way I handle this in voir dire is I say, do you go, first of all, identify people that have gone to a bar and a restaurant before. Obviously, there's parking lots there, so people drink, and then they have obviously driven, they drive away. And ask what happens when you drink a drink. You feel the effects, right? That's why people drink. What happens when you have 2 drinks? You feel the effects of the alcohol. Maybe even 3 drinks, you feel the effects of the alcohol, right? But when you left, were you intoxicated? And nobody will ever admit that they were. There was one guy, I think one time, said, yeah, I've driven, I shouldn't have been, but I was. Most people will say, no, you can have 2 to 3 drinks and drive and you won't be intoxicated, but you still feel the effects of the alcohol. So, and I say, okay, so what if you were pulled over after that and an officer said the same thing? On a scale of 0 to 10, 10 being intoxicated, 0 being sober, what number would you say? And I say, well, you wouldn't say 0, would you? And they say, no. And I asked them, why wouldn't you say 0? I say, because we've been drinking, and 0 indicates that you haven't had anything to drink, basically. Well, what do you think about saying like a 2? Is that admitting you're intoxicated? And they're like, no. Or what about a 3? No. It's just saying, we haven't had nothing to drink, so we've had some to drink. We feel the effects, and admitting a 2 or a 3 on that scale isn't saying you're intoxicated. So if you have that fact in your case, you can deal with it in voir dire, and the jury you frame it that way, the jury will already be expecting it. And when they hear it, it definitely takes some of the stigma off, and they don't think it's an admission of being intoxicated. So we had a case this week. This will be my last question. Real interesting situation where my client said to the officer, I'm drunk, whatever, can I just have a cigarette? So this was a big piece of the story that the state told in their opening statement. And I knew it would be something hard to deal with, and we'd have to address it. And the state oversold their case a little bit. They left out the word whatever when they were telling the jury about it. So when it came time to cross the officer on it, I started with that. I dealt with it head on. I said, look, we've got this video, and she says, I'm drunk, right? And that sure sounds like an admission of, I'm drunk, I'm intoxicated, I'm admitting to you that I'm intoxicated, right? I mean, that's one way to look at it, right? And he admitted that that's one way. I said, but that's not all she said, right? She said, and the state didn't ask you this, and this was kind of left out, but she also said the word whatever after that. She said, I'm drunk, whatever. Can I have a cigarette? So we went through, we took a step back after that. And we said, look, we know that she smokes. We know that's probably an unhealthy life decision. It's not healthy to smoke cigarettes, but we all make different choices in life. And for people that smoke a lot, it's hard to go for a short time without a cigarette, right? And he had answered everything in the affirmative, and she had already been under investigation for DWI, already did the sobriety test. He had already arrested her. She was in the back of the car. She knew that she was going downtown and she was arrested. Her boyfriend was an HPD officer. So, I mean, she knew what was going on. And I said, look, another way to look at this is, you know what? I get that you've already concluded that I'm intoxicated. I get that. I'm drunk, whatever. You got to do what you got to do. Can I have a cigarette? She wanted a cigarette bad, and I said, so, I mean, you can see that you can see it that way too. That's another way to look at what she was saying. It's not like an admission, like she's saying I'm intoxicated, but it's like, you know what? Look, you think I'm drunk, whatever. I get it. You got to do what you got to do. And that was that. And he agreed. He said, yeah, I think you could see it that way as well. Certainly nobody's going to just admit to the officer that they're intoxicated like that. Certainly you should never do that, even though some people do. But that's not what she was doing. As a matter of fact, later on a written interview that she signed, and after Miranda warnings, she said, "No, I'm not intoxicated." But the jury found her not guilty. It was a .14 blood draw. The state oversold their case. They did a couple things that they attacked me personally. Actually, they accused me in front of the jury of trying to coerce a witness to not appear in trial, and I did take it personally, and I addressed it on cross, and I disclosed my discomfort with that and that accusation to the jury in my closing argument. In 14 years, I've never been accused of anything unethical like that. I pride myself on my ethics and integrity in trial, and I was really offended. And the jury didn't like that either. So that's it for this this edition, April 24th, 2015. I appreciate you tuning in. It's Tyler Flood, Houston, Texas, DWI defense attorney. Our email is tyler@tylerflood.com. Or if you're going to email questions ahead of time, which I encourage you to do, use office@tylerflood.com. And we will be back next Friday, April 3rd, or is that May 1st? Anyway, next Friday, same time, 2 o'clock. If we have more questions, we'll go on longer, but we're going to try to limit it to 30 minutes. If we have an hour's worth of questions, I'll sit here and talk to you for an hour. So long for today.